Good day everyone. For today's discussion, we are going to tackle about rescissible contracts. Rescissible contracts. Rescissible contracts are valid because all the essential requisites of a contract exist. By the reason of injury or damage to one of the parties or to the third person, such as creditors, the contract may be rescinded. When you say rescissible contracts, actually, valid naman talaga siya. Yung lahat ng essential requisites of a contract exist. But for some reason of economic injury or damage to one of the parties or to the third person like yung mga creditors, yung contract ay pwedeng ma-rescind dahil nandoon ang defect niya by reason of economic injury or damage to one of the parties such as lesion. Next is requisites of rescission. The following are the requisites before the remedy of rescission may be availed of. First is contract validly agreed upon. Second is lesion or pecuniary prejudice to one of the parties or to a third person. Third, must be based upon a case specially provided by law. Fourth is no other legal remedy to obtain reparation for the damage. Fifth is party seeking for rescission must be able to return what he is obliged to restore. Sixth is object of the contract must not legally be in the possession of third person who did not act in bad faith, and period of filing the action must not have prescribed. Mutual dissent. Question. Suppose the parties to a contract mutually agreed to cancel the contract. Is this rescission properly so called? The answer is no. Of course, in a loose sense rescission may be used here, but strictly speaking, this is mutual backing out and not the rescission referred to in Article 1380 of the new Civil Code. In mutual withdrawal, it is the will of the parties that constitutes the basis, whereas in rescission, properly called, it is the law that constitutes the basis.
J. Nature of recessions. Recession is not a principal remedy, it is only subsidiary, meaning that it can be availed of only if injured party proves that he has no other legal means aside from rescinding the contract to obtain redress for the damage caused. Article 1177, even if the contract is covered by Article 1381. Ang ibig sabihin, pagbawi ay hindi isang pangunahing lunas, ito ay subsidiary lamang. Ibig sabihin, maaari lamang itong pakinabangan kung napatunayan ng napinsalang partido na wala silang ibang legal na paraan maliban sa pagbawi ng kontrata upang makakuha ng kabayaran para sa pinsalang dulot. Questions. Is the remedy of rescission subsidiary in nature? Yes, for it cannot be instituted except when the party suffering damage has no other legal means to obtain preparation for the same. Next is extent of rescission. The entire contract not be set aside by rescission if the damage can be repaired or covered by the partial rescissions. The rescission shall only be the extent of the creditor's unsatisfied credit. The policy of the law is to preserve the respect the contract, not to extinguish it. Ang buong kontrata ay hindi kailangang isantabi sa pamamagitan ng pagbawi kung ang pinsala ay maaaring ayusin o sakop ng bahagyang pagbawi. Ang pagbawi ay dapat lamang sa lawak ng hindi nasisihang kredito ng nagpautang. Ang patakaran ng batas ay upang mapanatili o igalang ang kontrata, hindi upang patayin ito. Questions. Maria brought a parcel of land from Juan. Maria brought action to rescind the contract on the ground of non-delivery of the property. Does Juan have to give also the fruits received in the meantime? No, the fruit received need to be given to Maria because the right takes place only when the delivery of the things sold has been made. Letter K, when the remedy of the recession is not allowed. First, if the party who demands recession cannot return what he is obliged to restore under the contract. Article 1385, Part 1. Recession creates an obligation of mutual restitution. General rule na makikita natin sa first paragraph, yung plaintiff o yung compliant demand recession, dapat he must be able to return what he has been received by the virtue of that contract, that rescissible contract. And it also include, diba, the fruits, pati mga interest ng price, kailangan i-return. Dapat you have the ability to return that the thing you owe to the other party para mag-demand ka ng recession. Second paragraph is, if the property is legal in the possession of a third person who acted in the good faith. Sabi dito, di ba, person who did not act in bad faith. Pag yung bagay daw na possessions na ng tao. Legally in the possession of the third person who did not act in bad faith, so meaning in good faith. Pag yung bagay ay nasa legal possession na, the third person who is good faith, hindi mo na rin makukuha yung bagay na yun from the third person. Pero take note, meron siyang requirement. First, that dapat in legal possession siya. Second, dapat hindi siya nag-a-act ng bad faith, so meaning in good faith siya. Pag ganyan, mahirap na mag-rescind ng contract. Third, the remedy in such a case would be demand indemnity for damages from the person who caused the loss. Kasi hindi na pwede si rescission of contract, then indemnity for damages na lang. The indemnity from that person, from that guilt person.
Badges of fraud. Article 1387. All contracts by virtue of which the debtor alienates property by gratuitous title are presumed to have been entered into a fraud of creditors, when the donor did not reserve sufficient property to pay all debts contracted before the donation. Presumption of fraud. This provision or article establishes presumption of fraud. Meron ditong two scenarios. Una ay ang in case of gratitude alienations, and the second is kailanman magkakaroon ng presumption of fraud sa onerous alienations. So, ang alienation is an alienement property. Another term is transfer of property from the debtor or from the owner to the other person na na-alienate mo. Magkakaroon ng presumption if it was done to defraud the creditors. Pag si donor ay hindi nag-reserve ng sufficient property to pay all debts contracted before the donation. So, ang example nito ay kapag si Nicole ay nag-donate ng properties kay Rose, but before niya dinonate ang kanyang properties to Rose, nagkaroon siya ng maraming utang. At nung dinonate niya ang properties niya na alam niyang yun lang ang natitirang ari-arian niya, ay dinonate niya ang lahat-lahat. Di siya nag-reserve ng enough portion of that to pay sa mga previous obligation niya, which alam naman niya na magiging due demand of all demandable eventually. Rules by which fraudulent character of transaction may be determined. First, fictitious or insufficient consideration. Yung mga consideration na di tunay, gawa-gawa lang, or kulang sa patunay. Second, conveyance is after suit is filed and while it is pending. Kumbaga yung process ay may implement pa lang pag yung kaso ay naitatag na or kahit nakapending pa lang. So, third, sale on credit by insolvent debtor. Ito yung creditor na nagpapautang kung saan magbibigay ng kabawasan sa utang o magbibigay ng konsiderasyon. Fourth, evidence of insolvency or large indebtedness. Yung kapag may malalaking utang or napatunayan mong may record itong malaking utang. Fifth, transfer of all of debtor's property. Kapag ibinigay lahat nito, lahat ng kanyang pag-aari o lahat ng kung anong meron ito. 6. Transfer is between father and son when some of above is present. Palitan ito sa pagitan ng ama at anak kapag present ang mga nakakataas dito. 7. Failure of vendee to take exclusive possession of the property. Ito naman yung kamalian or palpak na pagkuha ng debtor sa nasabing pag-aari. Period for filing action for rescission. So, dito naman papasok yung Article 1389, which is the action to claim rescission must be commenced within 4 years. For person under guardianship and for absentees, the period of 4 years shall not begin until the termination of the former's incapacity or until the domicile of the latter is known.
Answer: no. The rescission will no longer be allowed because the action has already prescribed. The action to claim must be commenced within 4 years. Question: when Pedro was 13 years old, he was under a guardian who sold in his behalf but without judicial authority the harvest in the farm that he owns, and in so doing the ward suffered a lesion more than one-fourth of the property. How many years will be given Pedro to rescind the contract? Answer: Pedro will be given 4 years after reaching the age of majority, the time the guardianship ceases. Hence, before reaching 22 years of age, the former ward should already have sued for the rescission of the contract. The injured party or the defrauded creditor. Because siya yung naaagabyado, siya yung biktima at kailangan ng hustisya para sa kasalanang nagawa sa kanya, which is yung nabenta yung harvest niya sa kanyang farm without consent from the owner. Second, his heir or successor in interest. Kasi sa kanya yun, ipapamana or sa kanya nakapangalan. Once na may nagalaw or nagawang kasalanan doon sa pagmamay-ari, ay damay din sa kanya yung damage na nagawa kasi nakapangalan na din sa kanya. Third, creditors of A and B by virtue of Article 1177 of the Civil Code. Actions abrogatoria, voidable. Voidable contracts. Article 1390 to Article 1402. Definition: voidable contracts are valid until annulled unless there has been ratification. In a voidable contract, the defect is caused by vice of consent. So, ang kasunduan ay mawawalang bisa kung ang mga ito ay walang kapahintulutan sa ang batas sa kanila. Ito ay isang pagkakamali, kaguluhan at pinilit ang isang partido. Voidable contract not void ab initio. A contract where consent is vitiated, such as by violence or intimidation, is not valid ab initio but only voidable and is binding upon the parties unless annulled by proper action in court. Ang ibig sabihin ng void ab initio ay the contract has no legal effect, not legally binding or enforceable. Void ab initio means that the contract is not valid from the very beginning. While voidable contract, it is valid and it can be void due to some changes in condition of both parties. Annulment is a remedy provided by law for reason of public interest for the declaration of the inefficacy of a contract based on a defect or vice in the consent of one of the contracting parties in order to restore them to their original position in which they were before the contract was executed. So, it is a remedy allowed by law to avoid entering into a voidable contract. Avoid meaning to validate the contract. Para mapawalang bisa natin yung voidable na contract, kailangan nating mag-file ng annulment. Ang pwede lang mag-file ng annulment ay yung injured parties kasi magiging unfair yon kung ikaw yung injured tapos ang magpa-file pa ng annulment ay hindi yung injured parties.
Letter B. Grounds for annulment. Declaration of nullity. Letter A. Incapacity to consent. Ang ibig po sabihin nito kapag ang isang nasa hustong gulang ay hindi pumayag sa or tumanggi sa mga medical na pamamaraan o panggagamot dahil sa kawalan ng kakayahan, May mga batas na nagtatadhana kung sino ang maaaring gumawa ng desisyon. Ang ilang mga tao ay hindi makakagawa ng mga desisyon sa isang tiyak na oras, ngunit maaaring magawa ang mga ito sa ibang pagkakataon. Example, if a house is built with conjugal funds on the husband's lot, the house and the lot will be both considered conjugal, with the husband becoming the creditor of the conjugal partnership to the extent of the value of the lot. Should the husband sell the house and lot with his wife's consent, the sale would be voidable. Letter C. Period for filing action for annulment. Article 1391. The action for annulment shall be brought within 4 years. This period shall begin in cases of intimidation, violence, or undue influence from the time the defect of the consent ceases. In case of mistake or fraud from the time of the discovery of the same, and when the action refers to contracts entered into by minors or other incapacitated person from the time the guardianship ceases. The 4-year period for bringing an action for annulment of a voidable contract is reckoned. First, in case of intimidation, violence, or undue influence from the time the intimidation, etc. cease. Second, in case of mistake or fraud from the time it is discovered. This must be so because before the time of discovery, the innocent party is unaware of the reason which renders the contract voidable and can be exempted to bring the action in court. Third, in the case of contracts entered into by minors or incapacitated person, from the time the guardianship ceases, an incapacitated person has no capacity to sue.
Good day everyone, I am Shane Rabe Sabala and I'm here to continue the discussion about defective contracts which is involved, rescisable, and voidable. The ratification means that one voluntarily adopts some defective or unauthorized act or contract which, without his subsequent approve or consent, will not be binding on him. It cleanses the contract from all its defects from the moment it was constituted. Article 1390. Hence, the action to annul is extinguished. Article 1392. An example of this is when parties sign a contract, the signing of the contract makes it official, and it can be enforced by law, should need arise. Kinds of ratification. A. Express, oral, or written. Ito ay yung pagsasalita ng kontrata. B. Tactic, imply as from conduct implying a waiver. Ito naman yung pagsulat ng kontrata. Examples of tactic. The first one is a minor bought a land but sold the same after reaching 21 years of age to a third person. Second, use of the proceeds by person who have been preciously intimated into selling his property. Ito ay example ng tactic dahil ito ay nangangailangan ng waiver. Requisite of ratification. First, the requisite for implied ratification are the following. A. Knowledge of the person which render the contract voidable. B. Such reason must be clear. And last one is C. Injured party must have executed an act which necessarily imply an intention to waive this right. Second, the requisites of express ratification are the same as those for implied ratification, except that the former is effected expressly.
And the letter E, the effects of annulment are: first, if the contract is not yet complied, then as simple as that, all of the parties that are involved in that contract are excused from performing their obligations. And the second one is, if there is now a compliance of the two parties, there must be mutual restitutions in general of the thing with fruits and the price with interest. Doon magkakaroon na ng mutual restitution, which means magkakaroon ng pagbabalik or pag-restore ng gamit o kaya pera na involved sa contract ng dalawang parties. So in duty of mutual restitution upon annulment, naka-indicate sa Article 1398. So according to Article 1398, if the contract is annulled, the parties, again as a general rule, must restore to each other the subject matter of the contract with its fruits and the price thereof with legal interest. And in personal obligation, where the service had already been rendered, the value thereof with the corresponding interest is the basis for damages recoverable from the party benefited by the service. Sa madaling salita, ang Article 1398 requires you to return what you have received under that contract if nagrant na ang annulment, and there will be a mutual restitution o pagbabalik or pag-restore ng gamit o kaya pera. And when it's about rendered services, wala nang balikan kapag serbisyo ang pinag-uusapan. And kapag serbisyo ang subject matter, then it will be converted to a recovery of a monetary damages. In addition, who may invoke this restitution? It is only the between the parties who are privity with the contract, and the stranger to the actual contractual relation cannot invoke the benefit of this provision. For example, if sale of land is annulled, doon napapasok ang mutual restitutions, kaya naman ang seller must return the purchase price with legal interest and the buyer must return the land with its fruits. So we are now in the effect of loss through fortuitous event. So kung babalikan natin ang Article 1174, the meaning of a fortuitous events is it should be responsible for those events which could not be foreseen or which, through foreseen, were inevitable. For example, suppose the innocent party cannot restore because of a loss through a fortuitous event, may he still compel the other to return what he had given? And the answer is no, because before annulment, the contract is valid, and the innocent party, being the owner of the thing lost by fortuitous event, must bear the loss. There is, however, an exemption, and it occurs when he offers to give the value of the thing, and he must be allowed this remedy. Otherwise, he will be in a worse position